Okay, you may proceed, counsel.
Thank you, Your Honor. May it please the court. My name is Kevin Hennessy with the law firm of Lewis, Longman and Walker, attorneys for appellant Persad Properties. I'd like to reserve 3 minutes for rebuttal.
All right.
Your Honors, we're here on a review of a final summary judgment holding that appellant's existing non-conforming use, allowing the sale of alcohol on the beach in the town of Fort Myers Beach, had been abandoned pursuant to the plain language of the town's ordinance. The parties agree here that the standard of review is de novo. We have 4 points of error that we're alleging by the trial court. The first point is that it was error for the court not to consider the case law requiring intent for abandonment and finding that the Bow Point case from this court was not controlling. The second error was construing section 34-1264 of the town's code as finding abandonment had occurred in this case. The third error was that the trial court did not find a violation of the appellant's due process rights. And the fourth error is that the finding that no taking occurred. With regard to our first point, Florida case law has long held that you must have intent to abandon a non-conforming use.
Yeah, this is a good place to start. The judge's order leans heavily on the finding that there's a kind of a restrictive definition of abandonment in this ordinance, which is strictly tied to the lapse of time. In other words, if you read the language just restrictively in black and white, it doesn't really talk about anything other than the time passage and the notion of imposing an intent component isn't found there. So I need you to explain to me why we should get beyond what the trial judge found to be the plain meaning of what the ordinance holds versus finding an intention, because I think a fair reading of this record is that these developers would not have intended to abandon this right in the traditional sense of abandonment, but the definition we're working with is perhaps more restrictive than what we all might think of when we think of the word abandon. So point me to the cases that you're relying on.
Absolutely, Your Honor, and the cases are replete in this regard. And I would say in response to your question, 2 points. Number one, that the court does misread the code in reading it as narrowly as she did. But secondly, probably the most recent case that actually speaks to what I think the trial court was believing was that there was a rebuttable or a conclusive presumption of a passage of 9 months and automatically abandonment occurs. That was the same situation faced by the 4th DCA in Cook versus Lake Worth. And in that case, the 4th district stated that at best, the ordinance creates a rebuttable presumption and that presumption would be rebutted by evidence of intent not to abandon. The Sarasota County versus Bow Point case, of course, is the one that's come out of this court in 2007. And in that case, you had another county ordinance declaring abandonment if a non-conforming use ceases for more than 365 days. This court determined that 365 days was not conclusive, where the motel owner was shut down doing repairs and renovations. And it cited to the City of Miami Beach case versus State XREL Parkway. That's exactly the same situation you have here, where you have an ordinance that's purportedly got this bright line deadline in it and doesn't mention intent, but in at least that one provision. But in any event, this court found that because, like here, the business was shut down, but was shut down for necessary repairs and renovations, there was no intent to abandon, and therefore there was no abandonment. And as I stated, and this was my second point on appeal as well, that there is a misreading of the code. While there is a definition of abandonment in section 34-1264 parens H parens 2, which talks about abandonment shall mean failure to use the location for consumption on the premises purposes as authorized by the special exception, administrative approval, or other approval. When you go to the next subsection, which is I, in 2 points, subsection D, it states failure to renew a state liquor license or written declaration of abandonment by the tenant and owner of the premises if under lease, or by the owner himself if not under lease, is grounds for revocation of
Your opponent would say that the abandonment definition under H2 controls, because we're in the section that deals with non-conforming establishments. We're not in the revocation of permit section. So how do you respond to that?
The non-conforming establishments provides as definitions. The clearly subsection H still deals with non-conforming establishments because it's special exceptions, administrative approvals, or other approvals. That language, special exception, administrative approval, or other approval, is the same language that's used in subsection H parens 2. And as well, that same language is used in subsection 2, which talks about prior to revoking an administrative approval, special exception, or other approval for alcoholic beverages, the town council shall conduct a public hearing at which the permit holder may appear and present evidence and testimony concerning the proposed revocation. So there's a long history with regard to the courts concerning land use, which is that a land use is an important substantive right, or property is constitutionally protected here in Florida, and as such, there needs to be an opportunity to appear and present evidence in opposition to the loss of a non-conforming use. The appellee would argue that there is some just disappearance of this vested property right based on a passage of time, which does not require any action by the city other than some staff member making a determination that 9 months had passed. That is clearly does not yield a harmonious reading of this entire ordinance, which provides for the dealing with a permission to or approval or right to sell alcohol, and the revocation of that right can only be done by the town council, and it can only be done under certain circumstances as defined in subsection I, and it can only be done with proper notice and opportunity to be heard and present evidence. To suggest that none of those safeguards of the loss of this property right would exist in this circumstance because it's not a permit approval is just inconsistent with the facts that the protections that exist for such an important property right. The zoning this is a zoning ordinance as well, and it's important to note that as a zoning ordinance, it should be construed in favor of the property owner. And we've cited the Rinker versus City of Miami case, which is a Supreme Court case from 1973. We would direct the court's attention in construing this ordinance to both the Rinker case, which states that you have to look at the whole ordinance in construing the intent and not just one part, and also the Forsyth versus Longboat Key Erosion Control District case of Supreme Court case of 1992. I would suggest that that case is particularly applicable because in that situation, you had a determination of is a district an independent district or a dependent district, and the statute in question had two definitions, similar to the fact that what's being argued here, that you had two definitions of abandonment, and it indicated that those had to be harmonized, and the only method of harmonizing those went in the Forsyth case was the fact that the fact that the district was straddled two counties. The ultimate language stated that a district that includes more than one county is an independent special district. So that language, it stated, had to be given effect. And the idea that an establishment that continually maintains its state liquor license, such as you have here, even though it has suspended business activities with the public, shall not be deemed to have been abandoned for purposes of this subsection. That has to apply to this case, and there's no rational basis to argue that that should be limited based on whether the business is being operated pursuant to a permit or based on a grandfathered non-conforming use, as is this case. If anything, there is an elevated property right in the case of Prasad, the appellant, than it would be someone who merely had a permit.
It looked to me like, if I'm reading the record correctly, that the whole notion of a 9-month lapse in serving alcohol, in exercising their rights under the non-conforming use, the issue wasn't raised until after 9 months had already gone by. Is that accurate? In other words, nobody was talking about this until the time if there is no intent requirement, the time had already run by the time anybody raised this issue.
That's right. If anything, the appellant was blindsided by the actions of the town, because they had been led all along to believe, as is evidence in the record, that the maintenance of the permit and the continued diligent repairs and renovations were sufficient to ensure that that there would be no lapse, there would be no claim of abandonment.
Yeah, as I was reading the planner, the town planner Noble, he appears to be of the opinion that because of the fact that they were actively involved in the renovation, there was no abandonment, and this provision should not have been applied. He continues to hold that opinion to this day, I suppose. And it was a little unclear as to how he was actually overruled. I think there was something in the record about the mayor getting involved, and I never saw where there was an actual vote, but for some reason,
there was not a vote.
Interpretation did not carry the day.
There was not a vote, Your Honor. What the situation was that there was a meeting with Mr. Prasad at the town in October of 2015. At that time, several town officials were present, including the city attorney, but most importantly, the mayor, who, as Mr. Noble said, took over the meeting and basically said, established her reading of the code based on her communications with, frankly, citizen opposition to this continued sale of alcohol on the beach, and hotboxed Mr. Prasad in stating that they would, under no circumstance would an employee of this mayor, meaning Mr. Noble, sign off on the certification that the zoning was appropriate for sale of alcohol on the beach. So essentially what you have is a coercive effort by the town mayor, both on my client and on her own staff, threatening that they would be fired if they did not deny the continued right to sell alcohol on the beach. And that, in fact, leads into the due process argument that the appellant was entitled to and denied. And again,
Counselor, just to let you know, you're at your 15 minutes, so you've got 5 left. I know it's going by quickly, so use it as you choose.
I'm sorry,
You have 5 minutes left. You can either use by rebuttal or continue your argument. That's up to you.
Well, I'm going to continue my argument for 2 minutes. I only need 3 minutes for rebuttal.
Okay. I think you did ask for 3, come to think of it. Go ahead.
Breaking with tradition of the other arguers. Due process is spelled out in 34-1264I. It states, as I quoted earlier, they're entitled to a notice, entitled to a hearing. That was denied. My last point was the actions of the town amounts to a compensable taking. We feel the law is clear that the deprivation of a non-conforming use is a compensable taking, and it's cited to 3M versus City of Tampa, Supreme Court 2nd District, this court 1991. And the town's action of hotboxing Mr. Prasad and extorting him out of his non-conforming use is exactly the type of demand that runs afoul of the takings clause. And we've cited the Coons versus St. John's, a US Supreme Court case on that. We would request that you hold that the town illegally withheld certification of the non-conforming use, that Mr. Prasad was denied due process and effectuated a taking of appellant's property right. We would request that you reverse the judgment of the trial court and remand for further proceedings consistent with your decision. And I reserve the rest for rebuttal.
Okay, thank you. Mr. Gill.
May it please the court, Your Honor, Hudson Gill on behalf of the town of Fort Myers Beach. We ask that the court's ruling be affirmed, and as Mr. Hennessy explained, that there are really 4 counts that were at issue here. Counts 1 and 4 were for declaratory and mandatory injunctive relief, which dealt with the content of the ordinance at issue, and then a taking and due process clause. With respect to the interpretation of the statute.
Mr. Gill, it's kind of tough to hear you. Is there anything you have any volume control on your side that you can make yourself louder or not?
Yes, Your Honor. Is that better?
Okay, that's better.
Okay, I apologize. What we would say here, Your Honor, is with respect to counts 1 and 4, it's an issue of interpreting the ordinance at issue. And the question really is, does the town or any municipality have the ability to adopt an ordinance that is contrary and alters Florida's common law? There are cases that they cite, the Bow Point case and some other cases that deal with what is essentially the Florida common law regarding abandonment. And I can touch on those in a minute, but I would submit to you, Your Honor, any governmental entity in the state of Florida has the ability to pass an ordinance that alters Florida's common law so long as it is constitutional. There is no facial constitutional challenge here to this ordinance, right? They're just—
Mr. Gill?
Yes.
And so they have the constitutional right to pass their own laws, and then equally so, they have the right to interpret those laws, right? And the courts have given them deference to interpret their own laws. And so I want to follow up on a question that Judge Black had as far as the land planner. So what weight then should the trial court have given to the evidence that the land planner would have interpreted this to mean that there was no abandonment?
Yes, Your Honor. So as you recognize, the agency, and in this case, municipality's interpretation is entitled to deference. Also, this was a matter of first impression for the town. This had never come up in the history of the town that anyone was aware of interpreting this specific provision. And I think if you look at Mr. Noble's testimony, and he is the former town planner, so in the hierarchy, there was people above him, including the community development director, and then the town manager. And Mr. Noble's testimony was that they'd never been called upon to interpret this. In other circumstances, I question him on this, in other municipalities, he'd always understood it to have some sort of intent component, but he agreed that the town's ultimate interpretation was a reasonable one given the language used. And I can go word for word through it and explain that, Your Honor, but ultimately, I think he said, yeah, I've never done it this way in the past, but seeing
My concern with this case is simply this, that there's really nothing in the record to indicate that Prasad wanted to abandon their rights under this property. There's nothing that would indicate that, other than the restrictive definition of abandonment, of meaning, 9 months of not serving. But everybody knew that they were doing these renovations and upgrades in order to try to maximize the use of their privilege in that regard. In fact, the townspeople were reassuring him, don't worry about it, just get the place ready, and this 9-month provision won't be a problem for you. So I need to know whether we are to restrictively say, no, you let 9 months go by, you lose, or wait a minute, there's an intent component here that they in good faith were trying to get back into business, and were being told that there wouldn't be an inhibition in that regard, and only to find that after they'd been closed down for a year at this October meeting that was referenced, they're told, after the deadline's already passed, they're told, no, sorry, you've lost this right, you've abandoned this right. And that it just seems like kind of as Judge Smith said in one of our earlier cases, it's kind of a gotcha, don't you think?
Well, I would disagree. It's a gotcha, and I'll say why, Your Honor. Number one, the corporate entity, Prasad Properties, like any other individual, was charged with knowledge of the content of the code. That's what the law says. Number two, there is no evidence that any member of the town told Mr. Prasad or Prasad Properties or any of its representatives before the 9-month period that this code meant something other than what it meant. He didn't ask them about it. That's what the record.
If that's your position, then what's the reason for putting the liquor license in escrow during the course of these renovations at the suggestion of the town people?
I don't believe that there is evidence that was actually done in advance where town people told him to do that, but it would be inconsistent with what the town code says. The town code controls over what some employee says at the town in any circumstance, and that's the case for any municipality. The policy of the town, as laid out by the town commission, is the content of the code, and that has to apply. I would submit to you, if you really dig down into what the evidence is and look what Mr. Prasad says, and when he says things occurred, they all occurred after the 9-month period happened. And even then, the town manager never told him that everything was gonna be okay. He said, the quote was really, just get it done and we'll do our best to get it open. So that's really the issue here. And again, if you look at the provision at issue, the plain language says, it defines abandonment, and it says abandonment shall mean failure to use the location for consumption on the premises purposes as authorized by the special exception, administrative approval, or other approval. I mean, it's clear on its face as to what the code says and what the requirements were.
Why doesn't our second DCA Bow Point case control this situation? Because there you had strictly a time limit attached to the abandonment clause, but our court had no trouble finding that, well, it's not that simple. You have to look at what the intention of the party was as well.
Well, Your Honor, with Bow Point, what I would say is this, and I have a couple points. Number one, Bow Point was a bit of a unique case in the sense that it was on second tier cert review. And so the court's review there and was looking at a decision where the lower court had found that there had been no abandonment. Discontinuance, I guess, is what the language of that ordinance used. So then on second tier cert, all the court was looking for was a miscarriage of justice, number one. So it's a bit of an odd procedural case in terms of what it was looking for. It wasn't a de novo review, it was a miscarriage of justice standard. Number two, that ordinance at issue doesn't have the strict definition or the clear definition that our ordinance contains. Shall mean, and that's what it says. Abandonment shall mean this. And there's no question that Prasad Property didn't come into meet that criteria. It was not serving alcohol for more than 9 months. And the issue is it's a separation of power issues. If our ordinance is clear and unambiguous, the rules of statutory construction say, the plain meaning rule says that's what controls. A court can't go in and alter it because it doesn't like what the municipality's done, absent a constitutional challenge. And they don't have one here. They're not saying
I understand that argument, but we also need to look at our second DCA cases and see whether there's ever been a situation where there's been a strictly a time ordinance, an ordinance where a time component is the very definition of abandonment. And in that respect, it looks like it has, that's exactly what the Bow Point Court was faced with.
Well, again, the wording used in Bow Point, the ordinance, is not the same as what we have here. I would say it's not as clear here. There's no discussion in that opinion of whether there's ambiguity in the ordinance. And I submit to you, if there's not, this court cannot change the words of what the ordinance says and say, we're going to apply our case law. The municipality, like anyone, has the ability to adopt ordinances subject to constitutional restrictions. That's not what we're dealing with here. Bow Point's not a constitutional case.
Are you familiar in your research? Did you take a look at the Hobbs versus DOT case from the 5th District?
Yes, Your Honor. The Hobbs case, if you can give me 1 second. Let me get my...
Because it appeared to me to be another case where the abandonment provision was tied to time, and the Hobbs court still imposed an intent analysis over the time requirement.
Well, I think the issue in Hobbs, Your Honor, was that the property owner himself who possessed the rights, the non-conforming use, wasn't aware that the tenant had tried to cancel this permit, and that really wasn't going to be held against him. Again, that's not what we have here. We don't have a clear and unambiguous statute that defines abandonment, which is what we have here. Those common law cases deal with the common law. If our statute is clear and unambiguous, then you get to that, and perhaps they dictate a different outcome. But if it's not clear and unambiguous, and our position is it's not, it's clear on its face, then there is no ability for the court to go to the common law. You have to apply the ordinance as it's drafted. And we submit that it's clear and unambiguous on its face, especially with what abandonment means. 9 months without serving alcohol. It's essentially what it provides. And that certainly happened in this case. With respect to what happened at that October meeting, and this ties into some of the other arguments, Your Honor, a meeting was called by the plaintiff in this case, Prasad Properties, in October of 2014, because they had heard that there was some potential issue with respect to whether they would be able to open with the sale of alcohol on the beach. At the meeting, there was discussion as to what the ordinance meant and what its wording was and whether it should apply. But the town's ultimate position is that the ordinance controlled, and because they hadn't sold alcohol for 9 months, they didn't have.
That was, you said 2014. That meeting was in 2015 because the time had already run by the time they had the meeting.
Exactly. And I apologize. That was a misstatement. I keep doing that. At that meeting, then, Prasad Properties had yet to submit anything to the town. After that meeting, it had several options to seek additional review. As we've laid out in our papers, the code provides that he could have either requested a written interpretation from the community development director regarding what the provision says, and then whatever that was, appealed that to the town commission, or he could have gone directly to the town commission after that meeting and said, I would like a written interpretation of what this means. If he goes to the town council, there's a hearing with a public hearing in terms of due process. That's all before he even submits his application. He has that right to seek that review. Alternatively, at the meeting, he could have submitted the application to the town. And here's what's also key with respect to what happens here. The application at issue is actually an application that goes to the state DABT, the Department of Alcohol, Beverages and Tobacco. And there's a provision in there that has to be signed by the town that basically says this conforms with the zoning requirements of the town. The process is, when that gets submitted to the town, it's reviewed by a person like Matt Noble. He explained the process is, first I look to see what the zoning is for the property at issue. If it allows it, then I just go ahead and sign off. If it doesn't, I have to look whether there's some other right that provides them to do this. In the past, it had been the non-conforming use. But now, with how 34-1264 operates, that had been abandoned per the code. And so he couldn't have provided that sign off. But in this case, what actually happened was Prasad Properties submitted the application without the sale of alcohol on the beach, and Noble could sign off on it because the rest of the property, the property not in the environmentally critical zoning district, allowed for the sale of alcohol. They opened the restaurant and went forward. Had he chosen, though, to dispute the town's interpretation, he could have filed an application that included alcohol sales on the beach, When Noble refused to sign it, or whoever else refused to sign it, he then could have appealed that decision to the town council and obtained a review that included a public hearing. He chose not to do that and instead seek relief in the court through declaratory relief, which is also okay, but he can't then come back and argue that there's been a due process violation by not undertaking the review procedures allowed under the code and then claiming we didn't provide him with due process. When the code provided him with that, he just didn't avail himself of that. So that's really the procedural due process issue. They also raise an issue, Your Honor, in the brief regarding substantive due process. And I just would like to say, number one, all the cases they cite there are federal due process cases. Federal and state due process are very different in a couple respects. Number one, the standard in Florida for substantive due process is really rational basis, which is what we just laid out, which as long as we have some rational basis, which the code provided us that rational basis, there's no substantive due process violation. The second issue with respect to substantive due process and really all due process, in the state of Florida, those due process claims, state constitutional claims, do not allow for the recovery of damages. It's a sovereign immunity issue there. There's been no waiver of sovereign immunity to sue for monetary relief under the Florida Constitution. As the cases I've cited make clear, absent some waiver like 768.28 for certain torts, you can't sue for damages. And that the case law I've cited is clear on that. The cases they cite are all federal due process claims, which the federal law in 1983 provides for a claim for damages for a state constitutional or a federal constitutional right. Now, with respect to the taking claim, Your Honor, which is also on appeal, our position there is fairly clear. They moved for summary judgment first. They said we're moving under the Penn Central theory of taking. There are 4 theories of taking. You have to proceed under one of those 4. There are elements to that which we've laid out. Although they didn't really even address those issues, the town addressed them, including citing undisputed evidence that established that the property retained value before and after this alleged taking. And the other elements, that being really the key one. And so under those facts, there's no basis for the court to overturn that ruling regarding the taking law. In their brief, they've argued that, well, certain cases like the Lewis case say that a abandonment of a non-conforming use is a taking. They don't say it is a taking. They said it could be a taking. You still have to analyze it under the appropriate mechanisms for taking law. And in this case, and the Gwynn case from this district lays out what that process is dealing with a single use. In that case, it was the use regarding short-term rentals. And the court said you still analyze that under the Penn Central analysis and its impact on the property as a whole. The problem they have here is that while they did lose a right to sell alcohol on a certain portion of the property, they were allowed to sell alcohol in the restaurant, on the patio, and they were able to open their restaurant and keep operating the business.
Let me ask you this question, counsel. Suppose that Prasad, rather than sort of acquiescing to this interpretation and saying, we'll just go ahead and apply with the DABT for a license that does not include the beach. Suppose they had said, well, listen, we don't read it that way. We're going to go ahead and start serving alcohol up and down the beach all day, every day, and twice on Sunday. And if you don't like it, you can come and revoke our license. Suppose they had taken that posture. In other words, forced a formal revocation.
Well,
would that bring subsection 34-1264 sub I into play?
I don't believe so, Your Honor, and I'll tell you why. Because under that hypothetical, they would not have been able to obtain they'd be operating without a permit to cite there. So it would be a code enforcement issue.
But if they took the position that they never lost it, in other words, that H2 doesn't apply to them.
Well, Your Honor, there wouldn't be an approval from the town then. So the town would just simply issue code enforcement violations saying you are doing something not permitted under the code, and it would go down a different component in the code regarding code enforcement. There'd be a citation, and then there would be that process that follows with respect to what code enforcement actions are, which is under Chapter 162 of the statutes. But again, Your Honor, they had the right to get a hearing here with respect to what our decision was. They simply chose not to avail themselves of that process. If that answers your question, Your Honor. I believe I've touched on all the issues that were raised in the by the court. If Your Honors have no further questions, I will rest and rely on the arguments raised in our briefs.
Okay, thank you, Mr. Gill. Mr. Hennessy, you've got your 3 minutes.
Thank you, Your Honor. First off, I would disagree with the assertions of opposing counsel concerning the planner's testimony. I think it's in accord with your statements that in terms of how he interpreted the code as not allowing abandonment without intent. Second of all, reading the language in the ordinance, nowhere does it say that it's seeking to be in derogation of the common law, which would be required. You would need to have clear language saying it's in derogation of the common law, which there is no such language. With regard to Sarasota versus Bow Point being second-tier review, that's a distinction without a difference. The question there was whether the correct law was applied. The court found and overturned 4 of the 5 grounds saying it was the incorrect law, but said that the requirement of intent for abandonment is the correct law, and that's why the ruling of the circuit court was upheld. I'd also point to the 3M versus City of Tampa case, another second district court case. In that case, it was dealing with a billboard and a reading of a Tampa ordinance. And while the city argued that the code provisions were explicit, demanding total removal of 3M's billboard, this court disagreed and clearly stated that an important right, such as that property right in that billboard, should not be subject to forfeiture without an opportunity for adequate correction. The courts asked about the Hobbs case. That also was a billboard case. That, in fact, though, was not, as counsel suggested, an ordinance, but in fact a DOT rule. And the court and that DOT rule did not have language with regard to intent, but it was placed on it and inferred on, imposed in by the court in the Hobbs case. The Lewis case, as we discussed earlier, is very analogous to this case because, similar to the town, there was wrongful conduct by the town. In this case, the hotboxing of Mr. Prasad into giving up his rights. In that case, the just utter refusal of the town of the commission to sign off on the certification. And in there, the court appropriately found that there had been no abandonment. Interestingly enough, Your Honor asked the question about code enforcement. What if we went down the code enforcement route? And I think that leads us to an important case that was in fact cited by appellees, which is the Massey versus Charlotte County case, which is a second DCA 2003 case, where it said the deprivation of a property right requires notice and opportunity to be heard. And in that case, in a code enforcement situation, this court found that there was a violation of due process because there wasn't a real opportunity to be heard, and there wasn't a true opportunity. There wasn't proper notice given there. And so similarly here, there was no notice of deprivation of this important right. And this is a right to sell alcohol. There's a long line of cases dealing specifically with licenses as opposed to a zoning right, but the application is the same, that notice and an opportunity to be heard and a statement of reasons for revocation are necessary to accord with due process. That due process was simply not provided here. Finally, with regard to the concerns being expressed about the Penn Central case, the weighing of factors, that's what Penn Central is about. And here we had a total loss of use of the beach for the sale of alcohol. That was what the purpose was for this entire, what was entirely at issue was the entire loss of sales on the beach. It was relied on in the reasonable investment-backed expectations of Prasad, and the character of the government action needs to be considered, and the character in this case should be abhorrent to the court in terms of this hotboxing extortion of a right away from the appellant in simply a fashion where not only was the appellant extorted or arm twisted, but staff was as well. Thank you. I appreciate the time. If there are any questions.
Thank you, Mr. Hennessy. That's all the time we have. Thank you both. Well argued.
Thank you,
And
Honor.
the court is now adjourned.